Greetings, colleagues and enthusiasts of corporate law in Kenya. My name is Mathews Okoth, and I want to take this chance to again welcome you to Corporate Law Turn-Up, a program through which I serialize some of the lead corporate news items in Kenya with a view to identifying some of the legal issues that those news items raise and to try and excite debate about the efficacy of the legal issues that are arising. Now, this is episode 4 of the program. In episode 3, I conceptualize a bond issue, players in a Eurobond issue, and the process itself of a Eurobond issue. In this episode, I will be looking at the regime for enforcement of investor remedies in a Eurobond issue in a comparative context. Now, the comparative regimes that I will be looking at are the Kenyan regime, the UK regime, and the US regime. The choice of these regimes, particularly the Kenyan and the UK regime, is informed by the assumption that we made in episode 3 that this particular bond issue by the Kenyan government will be floated at the London Exchange, therefore primarily governed by the English law. Now, we said, we discussed in episode 3 that because this particular issue is not wholly resident in the UK, local laws is relevant, is part and parcel of applicable law to the bond issue, to the Eurobond issue. And so an understanding of, at least some basic understanding of the Kenyan regime is equally important. Now, the choice of a US regime really is more of, just to identify some of the facilitative regulations that are available in that country on investor protection, to excite a debate amongst us on perhaps how we can improve our laws so that they be more investor friendly. Now, in episode 3, we discussed the document that actually forms the basis of a Eurobond issue. And we say that on the assumption that the Eurobond will be floated at the London Stock Exchange, there is a document called a prospectus, which we expect that at some point will be filed by the Kenyan government for approval by the securities regulator in that country called the Financial Conduct Authority, of course simultaneously at the London Exchange. Now, this prospectus, we said in episode 3, has 3 primary sections. We said there is a first section which discloses information about the issue itself, in this case the Kenyan government. That is called a registration statement section. We said that there is a section that discloses information about the issue, this Eurobond, 250 billion Eurobond, what it is all about, perhaps areas where it will be applied, the prospects of repayment for the bond itself by the Kenyan government. Okay, so all that information will be expected to be contained in a section called a securities note section. Then there is a third section, which perhaps is the most critical section of the prospectus, called a summary note section. And the summary note section actually identifies some of the risks that are involved that will be associated both with this issue and the issue itself, which is the Kenyan government. Okay, so that I think we fairly discussed in episode 3. Now, today, like we said, we look at the regimes on enforcement of investor remedies. In the process of these disclosures, not always that the disclosures will be correct. And so there's a critical question that arises that in the event that there's a misstatement in any of these sections of the prospectus, who really is liable for those misstatements, if at all someone suffers an investment loss as a result of subscribing to the shares. But before we look at whoever will be liable, just to establish a context, there are always two approaches that policymakers, take when they are trying to set out regulations for enforcement of breach of securities fraud. Generally, can be called securities fraud. One of the approach is always based on the assumption that there are sufficient players in the process of a securities issue that can be used as a very important tool in enforcing correct disclosures in the prospectus. This category of professionals that are involved in the securities issue, collectively they are called gatekeepers. So one of the gatekeepers that is actually mentioned in the news item is the lead manager. They are called investment banks. Some of them underwrite the loan. Underwrite means they undertake to pay the issuer the particular amount, of course, in concert with their network of investors. They get involved in the process of a securities issue at a very early stage of the issue. Like in this case, we are told already they are identified. There's Citibank, there's JP Morgan, their co-managers, we were told is I&M Bank, there's NCBA Bank. Collectively, they are investment banks. And their key role is they prepare the issue. They actually end up pricing the issue, okay? And it is their network of investors that end up investing in the issue. Such that if you look at that primary subscription to the Eurobond issue, it is primarily driven by these investment banks. And what persuades those prospective investors to subscribe to the issue is actually the reputation of these particular investment banks. And the same always is argued for auditors. Okay, if forget about a sovereign government, if we said in episode 3 that a Eurobond can also be issued by a company, or an investment grade company, they can borrow in international finance market. And one of the documents that will be filed as part of the prospectus is actually the financial statements of the particular issue, of the particular company that is seeking to raise finance through a Eurobond issue. Okay. Now the auditors, the ones that certify those statements, they have a choice in the process of auditing the accounts to give a qualified opinion about the reporting in the financial statements, or they can refuse to certify if they are persuaded that there are material misstatements in the financial statements. Okay, such that those who argue for an approach of voluntary disclosure, their key argument is that these gatekeepers they trade on their reputation. Okay, and so if they can, in the course of protecting their reputation, they discover that there's a misconduct, they can actually disrupt the process of the issue until that time when the disclosures in the prospectus are correct. Okay. Of course, there are people who have criticized that approach. If you look at, for instance, if you compare the number of investment banks that, for instance, can undertake such kind of bond issues, they're countable. Okay, a concept called concentration. So because of that concentration in the market, there is really no many alternative investment banks that can undertake some of these larger bond issues. Okay, yeah, and the same goes to auditors. I mean, you and me perhaps know some of the large auditors in the world. They are not many. Okay, with particularly the reputation to undertake an audit of some of these magnitude. Okay, so because of that concentration, they claim that because they have a reputation to protect or they lose business, may not necessarily fly. Some people argue that, look, there are never alternative choices. So whether or not they foster compliance in reporting in the prospectus, it doesn't really bother these gatekeepers. They will continue to be in business because they are the ones who are available for selection anyway. Okay. Other people argue that the loyalty of some of these gatekeepers really is never so much to the investors. It is to the paying issuers. They need to retain the business, okay, and to continue being in the panel of gatekeepers by these particular issuers, okay. And so when they're in the process of preparing whatever securities issue is in question, their focus really is never so much about the interests of the investors, okay. It is more to safeguard their jobs and to continue earning the large fees, and they are paid very well, these particular gatekeepers. So because of some of these inefficiencies in this approach, that enforcement in securities fraud regulation, you can only enforce through voluntary disclosure. There is therefore need for mandatory prescription of law that vests obligation on these gatekeepers, among other players, in the process of a securities issue, and with a very definitive liability, okay, that would then be suffered by whoever the liability vests in the event that there is non-compliance. That is the second approach, which is called a mandatory approach to securities regulation. So there are hard and fast rules, and there are rules in Kenya under the Capital Markets Act. There are regulations on securities listing and public offers, okay, which prescribe, first identify the incidence of liability, who is liable, the nature of the liability, and of course the penalties for non-compliance. The same applies to UK. They have a law there called the Financial Services and Markets Act of 2000, I believe, which also, to an extent, some very mandatory rules that identifies particular players in a securities issue that they have to comply with, okay, and liability if they fail. In the US, they have Securities Act and Securities Exchange Act, which also, as we will discuss shortly, also imposes certain mandatory obligations. The extent to which these three broad categories of regimes identify the incidence of liability and the threshold differ, and I think that will form the remaining part of our discussion. So there are certain themes, in mandatory enforcement procedures that we can look at. The first one is on who really has standing to enforce investor protection remedy. Who can commence a suit? Okay. In the event that it turns out, and let's just be clear what we are saying about what we are saying. In the event that in the process of Kenyan government, assuming theoretically it makes some misstatement in any of these three parts of a prospectus that it uses, that it floats at, assuming at London Stock Exchange, and a subscriber to that, to this Eurobond, suffers loss. Okay. Who has the the standing, who can competently sue which party. Okay, it's not obvious that it's only the Kenyan government that will be sued. Who can sue which party for what remedies? So under both Kenyan and UK and even the US, I think on standing, the three regimes are similar, nearly similar. Okay, it is only the party that actually purchased or subscribed to this Eurobond issue that would have the capacity or the standing to sue. Okay, so this is not the kind of a dispute where you can talk of public interest litigation, where an activist emerges and then tries to bring a suit on behalf of investors in the Eurobond issue. One of the requirements under the three regimes is that for you to sue, you must demonstrate that you subscribed to the securities issue. You must actually trace your subscription to the prospectus which you are saying there was a misstatement in. Okay? So the plaintiff has to be a subscriber either to the issue, or there are instances where, remember we said in episode 3 that selling these securities happen at two levels. There is at the primary market level, where there is the initial subscribers assembled by the lead managers to avail to the Kenyan government this 250 billion. Okay, then Kenyan government, in theory, exits the scene and is now obligation to repay that at the maturity of the tenure of the bond issue. These particular subscribers to the bond issue in the primary market, they have a discretion. If, for instance, their subscription is large, 250 billion, we say it is a large amount of money. So if someone say subscribe up to 100 billion shillings or underwrote up to 100 billion shillings of this bond issue, okay, they may decide to trade this subscription in the secondary market to other investors, in which case they become the offerors. Okay, so either for then a person who is aggrieved by the disclosures that are made in the prospectus, for them to have standing to sue, they must prove that either they subscribed to these bond issues in the primary market, okay, when Kenyan government was floating it in the primary market, or they bought it from an offeror in the secondary market. So either way, because even this offeror, before it actually is allowed to trade in that secondary market, there are certain disclosures that it will have to make about the risks itself and the issue. Okay, so standing is acquired by subscription to the particular issue. Okay, now against whom can a plaintiff sue? Okay, now, and this is one area where these three regimes then starkly differ. Okay, both in Kenya and in the UK, the liability vests in the people who are in control of the prospectors, and that has been described in certain case law to mean that it is the issuer and the controllers of the issuer. So in the context of a Kenyan government, it would be expected that liability, the defendant that can competently be sued to enforce an investor remedy in the event that the investor suffers loss as a result of a misstatement in the prospectus, the defendant that can be sued is the Kenyan government or an accounting officer of the Kenyan government. Okay, assuming that this was a bond issue by a county government, again, of course, there are players that will help that county government to float this Eurobond in the international finance market, as long as we say there is a guarantee by the national government and approval by the county assembly. But the defendant, in the context of the Kenyan regime and the UK regime, cannot be these gatekeepers who assist in the preparation of the bond issue. The defendants will be the county government and the accounting officer for the county government. Okay. Now that actually differs if you want to now compare with the US system, because liability can actually be claimed not just against the issuer, okay, but also the professionals that participated in the process of the bond issue. So, and there are cases there where not just the senior executives, the issuer, the senior executives in the issue have been sued, but also lawyers. Lawyers have been sued if they gave legal opinions that turned out to be misleading. Okay, or the auditors if they gave, the auditors that actually certified the statements that form the basis of the securities issue, and of course the investment banks that are the key drivers of the bond issue itself. So in terms of the defendants, okay, you can see that in Kenya is a bit limiting. Kenya, UK is a bit limiting. It's only the issuer and its controllers. If it was a company, it will be the company as the issuer, the directors of that issue, and the senior executives of the company raising the finance. Okay, and the story then stops there. Okay, but that's different from, in the US context where liability would extend to even the gatekeepers that were very instrumental in preparing the issue. Of course, if you are acting for the defendants as a lawyer, there are certain positions that you can take. It's not the mere fact that you are an issuer or you are in control of the issuer doesn't mean that you'll be automatically liable. You can say, for instance, just strategy for litigation, that look, the particular defendant did reasonable investigations, and if you can prove that before this particular statement that turned out to be incorrect in the prospectus was actually included, your client, the defendant, did some investigations, and if your client say is let's take in the context of a corporation, your client is a director, okay, of this particular corporate entity that is raising the finance, you can say, look, parts of these prospectus were actually prepared by experts. There were auditors, there were lawyers that they didn't prepare it, and I believed in the competence of this particular expert. So the defenses that are available, if you're not for the plaintiff, you are for the defendant, it's reasonable investigation and belief in the competence of the expert that prepared the expert part of this particular prospectus. There are certain parts of the prospectus where liability will likely be strict, like an expertise part, the parts which give routine information about the issue. You'll be expected that as a senior executive, you are aware, you're in a position to correctly disclose about, because it's non-technical, about the issue. Okay. Now, if for instance, there's the other strand of discussion in this mandatory disclosure. Again, we said the mere fact, the mere fact that the statement is incorrect doesn't mean that the issuer, its controllers, or where the regime requires even the gatekeepers are liable. Okay. In the context of Kenyan and the UK government, there is also a third requirement that whoever is suing the plaintiff must show that they suffered some loss. There's a concept called loss causation. Okay, so that this misstatement you're claiming that occasioned loss to you must have been the particular reason for your alleged loss of investment for you to succeed. Okay? What that means is this, that there are very many market factors that can influence a loss of investment. We are living in the generation of COVID, for instance. The mere fact that in a prospectus, just theoretically again, the mere fact that Kenyan government, for instance, underestimated or exaggerated its economic outlook of itself is not the only cause for a loss of investment. Okay, if there is, for instance, another pandemic that happened subsequent to the publication of this or after the securities issue, okay, that can still be traced to the cause, to be the cause for the loss of investment. If you are representing a client within the context of a Kenyan and a UK regime, the duty to disentangle all these other possible causes for investment loss vests with the plaintiff. Okay? But assuming, on a comparative level, assuming that this particular Eurobond issue was actually floated at the New York Stock Exchange, for instance, US law, okay? That is not the case, because there, all that is required is for the plaintiff to just show that this particular statement was incorrect, or there was a material omission in the prospectus. Okay. What then will be required of the defendant? This so-called loss causation. It is for the defendant to now persuade court that much as yes, this particular statement was incorrect, it did not cause the loss, the investment loss to this particular plaintiff. So that loss causation in that regime is then taken as a defense. Okay? The incidence of burden to prove loss causation shifts from the plaintiff to the defendant under US regime. Now, under the Kenyan and the UK regime, that incidence of burden vests in the plaintiff. Okay? And that's why, as we'll be seeing shortly, when we'll be seeing how inhibitive the UK-Kenyan system is to investor protection, one of the key arguments has always been not just the threshold of the burden, but also the proof of loss. It is a very difficult task for any party to disentangle, to separate all other factors in the market that can cause investment loss before they succeed in their claim. That obligation is eased in the US system. Okay? So that once you've proved, you have to show that this statement was misleading. Okay? You talked about political risk, yes, but in a context that underestimated its impact, for instance, in your economy. If you are to talk of economic risk in the context of the upcoming elections, as one of the risks under the summary, not part of the prospectus. Okay. So a plaintiff in the US will just be required to prove that you underestimated the impact of the change in government in your country to this securities issue. Okay. In Kenya and in the UK, you are required to go beyond that. Other than just saying, yes, it was incorrect statement, you have to show that this particular factor of understatement of economic risk, just theoretically, the impact of that misstatement is actually the cause of your loss. And there is no other cause other than that. That is the high burden that you carry as a plaintiff in these two regimes of Kenya and the UK. Now, because of some of these, higher obligations that vest in the plaintiff, particularly in Kenya and the UK, There have been attempts, and even in our country, there are case law in Kenya where people have tried to, enforce remedies, not through the statutory prescriptions, but under common law. Perhaps you've come across cases where investors have tried to seek remedies by invoking certain tortious acts, that if the statement in the prospectus turns out to be incorrect, someone can claim deceit, which is a tort, okay? But that's not again helpful. Well, other people claim, they call it negligent misstatement in the prospectus. But even then, they never get far. Let's, for instance, take a tort, a tort of deceit. That for you to succeed in a tort of deceit, you actually have to show fraud, intent to deceive. Okay? Now, it is unimaginable how an investor will be able to show that. An investor, how will they be able to show that this particular director of a particular issue, okay, intended to make the incorrect statement, which then is the only cause that led to my investment loss. Okay. Now, even those who try negligent misstatement, there's still not much help that they get. Okay, because negligent misstatement, principles of negligence apply. Okay, you must show duty of care, that you are owed duty of care by this particular defendant that you are suing. Yeah, and then that defendant breached the duty and you suffered loss as a consequence. Okay. Now, if the particular plaintiff is an investor who subscribed to the securities in the primary market, or let's say in the secondary market, which is quite common areas where some of these disputes arise, it is very easy for an issuer, like say in the context of a Kenyan government, to say that there is no proximate relationship between an investor trading in the secondary market and the issuer. Why? Remember, we said that selling of this Eurobond issue happens at two layers. There is the subscription at the primary market, and then those who subscribe then float the shares as the Eurobond issue as of arose in the secondary market. So that by the time that this Eurobond issue is floated in the secondary market, the Kenyan government has exited the scene. So Kenyan government can easily argue, if the governing law in that particular dispute is Kenyan law, and same situation even under the UK law, they can easily argue that this particular investor in trading at the secondary market, I had no relationship with him. Okay, the proper party to sue is the offeror that has sold these shares to the investor. Okay, so the point is that even under common law, it's still a hurdle for an investor to enforce remedies when it turns out that there is a misstatement in the prospectus. Okay, and so maybe just a point to reflect on as we try to maybe think through how we can improve this area of law. There are jurisdiction where litigation in securities fraud is really a big game for lawyers. Okay, and perhaps that is facilitated by the ease with which those particular relative ease, not so much ease, relative ease with which the investors are empowered to enforce remedies in the event that they suffer investment loss. Okay, for instance, there's a concept called an opt-out procedure in the US. Some of these investors, particularly in the secondary market, they're always in their thousands. Okay, and in the US, if there is a question raised in respect to a particular issue, all people, all investors that actually invested in that issue are automatically considered potential plaintiffs. And so what a lawyer, for instance, in that jurisdiction is required to do is only to identify one plaintiff, who then can bring a class action on behalf of all the investors in that particular issue. You can't do that here in Kenya. There'll be the requirement to prove authority to sue, for instance. Okay? That procedure in the US is called an opt-out procedure. Automatically, people, the investors in that issue are deemed to be plaintiffs. Okay? And unless that a particular plaintiff deliberately moves out of the particular suit, they will be deemed to be potential beneficiaries of that court process. Okay? In Kenya, you can't just start a class action. There'll be a requirement of authority to sue. Assuming these are investors that are spread all over the world, technically it's nearly impossible to get authority to bring a class action in their name. Okay? There is also another concept called the contingency fee arrangement, which is also another problematic area. Under Kenyan law, they say cause follow the events. Okay, cause follow the events. So before you go to court, there's always a nagging question that what if I lose? What if I lose against this particular defendant? There's always the fear that you will be subjected to huge costs, and you can imagine some of these disputes, they don't attract mega costs. The awards in costs are substantial, which of itself is inhibitive of enforcement of these investor remedies. Okay? Now, within the US system, the contingency fee arrangement is more facilitative. Okay? Because how it works is that there's just an arrangement. What a lawyer needs to do is to get a plaintiff suit. First, he is guaranteed that all the investors in that issue will be plaintiffs. And two, fees is based on outcome. And at times, some of these fees go as high as 30% of whatever recovery that they make out of the court process. And the losing party, once it's paid, the losing party doesn't have to pay costs. Okay? So, unlike in a situation where costs become a hindrance, that problem is addressed. And of course, it then facilitates court action in trying to enforce investor remedies. Perhaps those are issues we may consider for change in our legal framework. Thank you very much for listening to this episode 4, which has tried to, in a very simplistic way, highlight the regimes for enforcement of investor remedies, both in Kenya, UK, which are nearly the same, and with a comparative study of a US system, and try to identify some of the areas for reform that we can adopt in our country so that we can improve enforcement of investor remedy and expand that area of practice. Securities regulation in the US, those who are familiar with that system will tell you is one huge area of practice because of the facilitative processes in place. Okay, so perhaps if we can identify some of the best practices in that country that we can adopt in our regime, it can expand areas for practice for lawyers also in our country. Thank you very much. Again, my name is Mathews Okoth, and I thank you very much for listening to me, and also thank you for the continued feedbacks that I receive from you in this program. Bye-bye for now.